Hi, it's Neil here, and this course so far we've looked at sessions on how to source from China, supplier strategies, negotiation in China, and large buyer strategies. In this session we really want to look at what to do if things go wrong, because so far you're going to get to a stage where you've passed this course and you've done your marketing research, you've chosen your product design, you've sourced your suppliers, you've narrowed it down to 4 suppliers to visit, and you're going to visit the factory and you visit the 4 suppliers, and you had 1 supplier audited, maybe 2, you had the factory audit, you drew up the contract, you did the right things, you did the negotiation, you did the documentation, you did the measurement, so the auditor knows what to do, check the boxes, and you put a down payment of 30% to cover materials, another 30% payment at 50% stage, and then you pay the rest to FOB, and after a final inspection by the auditor, before shipping to the port, the supplier calls and says they have not received payment at the 50% stage, but you tell them that you sent it to a particular person's account. Or the supplier says they did not receive it and are not releasing the goods until you pay up. Or the supplier ships to the port and your goods have problems, unforeseen by the auditor, perhaps needles left in a soft cuddly toy. Yes, that does happen. Okay, so what do you do now? Look, there's always something that goes wrong, and so this session we're going to talk about what to do if things go wrong. So let's have a look at the decision matrix. Okay, something goes wrong here. Something has gone wrong. The supplier hasn't delivered. The quality is not there. It's too big to take back. You've actually lost business. It's not that the supplier's going to do it again for you and then you're back to normal. You're out of business. You've lost your reputation because you didn't deliver products on time. You've lost a distribution channel, etc. You've got to take the supplier to task on this. And so what are the different stages? Number 1, the letter of demand. The letter of demand is a letter that says, I'm going to make your life hell if you don't comply with this. And letter of demand is about a relationship. You're trying to, look, we've lost business, we're going to make your life hell, so you're actually impinging onto the relationship a little bit, but you're not using a higher authority, you're not using another institution to support your demand. It's just you against the supplier. The cost is going to be low, time is going to be quick. The supplier will tell you very quickly whether they're going to help you or not with that demand. They're going to ignore you likely, so therefore you're not going to get much alignment. Okay, it's not really going to help you, but you've got to go through that process. You've got to try and get that payment done through a letter of demand. Why? Because time is short and also the cost is very minimal. Okay? That you want to try that before you go to the next stage, which is the alternative dispute resolution. But let's have a look at the letter of demand. You need a licensed lawyer. It's going to have Chinese language. It's going to be sent to the legal representative, and the emphasis is going to be on debt collection, and it's going to be emphasis on action. And so the effectiveness really depends on how you measure effectiveness. Are you going to be very ruthless in that demand letter, so therefore you're going to destroy the relationship a little bit in order to get alignment? And so you're trading off a relationship versus alignment here, and it's not going to be very effective, and that's why the cost is low, and also the time is going to be quick, because you're going to find out whether you can get that damages or not very quickly. It can be effective because you can press on the relationship to say that you're going to take it to the next level, and the supplier may comply because they fear of being sued. Let's have a look at the next stage, shall we? And that's what is mediation. What do we mean by mediation? Mediation is where you get a third party, it's voluntary, and you come to an amicable agreement over who's going to be liable. Okay, so we're talking about a slice of the pie, and also over how much are we liable for. So what is the percentage of blame, and also how much is the penalty? How much does the supplier should owe? Okay, so there's civil mediation and judicial mediation. Obviously, you might try civil mediation. Now, you can't do any of this unless you set up in the contract that you'll go to mediation if something goes wrong. It's very hard to ask the supplier after something goes wrong that, oh, can we go to mediation, please? And the supplier will tell you to go jump in the lake. Okay, letter of demand, okay, that's basically you sign the contract, then you have a letter of demand. Look, there's a clause in this contract, you've broken the clause, letter of demand, straightforward, no worries. But mediation, you need to have a specific clause in the contract to say that you will go to mediation. And so that's the only way you can bring the other party to mediation if something goes wrong. You prepare for mediation by having it written into the contract as a clause. Then you do the mediation, you come to agreement and accept the dispute. There's some more information there to follow up. It's supposed to be friendly, and it is promoted by the government. So therefore, suppliers are aware about the idea of you having a clause in the contract for mediation. Let's have a look at the pros and cons of mediation. While a court case is a zero-sum game with a winner and a loser, parties in a mediation can think outside the box, discuss and agree on a settlement that is acceptable to both sides. And so this is the good thing about having mediation. So therefore, the relationship can be maintained. The cost is relatively low. The time is going to be very short, and maybe it's unlikely to meet your objectives because there's no third party that can enforce the supplier to comply with your demand. Okay, what about arbitration? Okay, arbitration, right from the get-go, like mediation, you need to have arbitration in the contract. But an arbitration is like a soft court. What do we mean by this? The decision by the arbiter is final, and both parties have to comply with arbitration. And so this is encouraged by China government too, because it actually reduces the waiting list in the court system. And so there's a dispute heard before a private arbiter, and there's a notice of arbitration. The agreement must be in writing, and so basically you need to put this into the contract. And it must include an express and clear intention to submit the dispute to arbitration if something goes wrong. And both parties have to agree to that. If it's not in the contract, you really can't go to arbitration if something goes wrong. So the relationship is likely to break down because this is kind of like a soft court. It is a formalized process. The cost is relatively low. It can be done in 3 to 4 sessions. And the time taken is relatively low. And the award must be rendered within 6 months of forming the tribunal. And alignment, there's more power. Why? Because the tribunal has a bit more power to enforce the outcome of the arbitration. Remember, you are locked in. You cannot go back to mediation. You cannot go to a friendly relationship after you go straight to arbitration. You can only go to one step further, which is to the court. And that's where we go to litigation, taking legal action against someone in court. How? Well, you need legal counsel, you need to have evidence, and you need to make sure that your contract is very clear in terms of terms and conditions, and that there's a very clear breach of contract. Without that, it's very hard to take the other party to court. So the relationship, again, no turning back. The cost. Litigation in China is relatively straightforward. It is affordable. But remember, you're going to lose that relationship. Time taken is relatively longer, but definitely quicker than the US or in Europe court proceedings. And also alignment. It's likely you're going to get what you go to court with, particularly if you have the facts on your side, you have clear penalties, you have a clear contract. So there we can compare arbitration and litigation. The cost is comparable. There's not much difference between the two. Time taken is not much difference between the two. But the independence of the judge, either party can choose the arbiter. But with litigation, judges are more likely to be influenced by the interests of local governments. Some judges in China are 24-year-olds, 25-year-olds just out of college, and they're suddenly thrust into judge positions without much experience in the field. That's the way it is in China at this stage. Okay, flexibility. Proceedings can be held with a foreign language, but with litigation, it's usually held in Mandarin. And the one thing to do is, if you're a foreigner and as part of litigation, you actually leave. When you go into litigation, it's going to be held in Mandarin, and it's best not to attract too much attention of being the white person in the Chinese court system. So you as the white person should sit outside while all the Chinese on your team go inside and do the casework. Again, privacy is arbitration, but once you go to litigation, it's public, and this is the leverage that you can include in your demand letter. That is, if arbitration fails and you show the other party that you intend to litigate, then that may be another leverage that you use in arbitration. That's another piece of leverage, because if we get a decision arbitration, then the Chinese can preserve their relationship, they can preserve their reputation, and that's very important for the Chinese. And so you can use that as your leverage when you're actually in arbitration with the Chinese. You can use that as leverage in the demand letter. If you don't comply, we're going to litigate. So the use of a threaten to litigate does have clout in terms of, well, you're threatening the Chinese to bring this dispute public. So keep that in mind. So here are the golden tips for alternative dispute resolution. You need to make these options clear in the contract up front. You need to make the options clear. If they're not clear up front, it's going to be very hard to do mediation. It's going to be very hard to go to arbitration if there's no clause in the contract. You need to specify the scope and type of problems that may be subject to arbitration. So even when they go to arbitration, okay, if it's not very clear, then that will be thrown out. And finally, who, where, and when arbitration should take place. Recommend Hong Kong for arbitration. It's an English language, and also it's just across the border from mainland China, and a lot of arbitration hearings are held in Hong Kong for that purpose. Okay? Of course, when you go to litigation, it's going to be in Chinese language, and that's going to be on China mainland. A few other golden tips. Prepare for the purpose of having the options if things go bad. So basically this whole session, of course, we got into some of the detail about the different stages: demand letter, mediation, then arbitration, and then litigation. But the whole purpose of going through this is, wow, I really don't want to be part of this. But if things go wrong, the only way that you can effectively enforce under any of these 4 areas is that you make things clear in the contract up front. So here's the big takeaway. Often we get lawyers in, and the lawyers will say, you need to have this, you need to have this clause, you need to have this clause. And basically this session is to help you appreciate more about why the lawyers are really telling you that why you need to have all these clauses in your contract. And you're thinking, do I really need all those clauses in the contract? That will make me look out to the Chinese party that this foreigner really doesn't really want to have a relationship, they really want to have a contract. Well, it's very important. You've got to get the contract clear, and you've got to have all that documentation in there, all those clauses, because if something goes wrong, then it's going to be easy to go up the ladder from demand letter to mediation, arbitration, and then litigation. And if you don't have it in the contract to start with, then you've got no leverage when something goes wrong. And that's I think that's the biggest takeaway from this session. Appreciate why the lawyers will want to have all these clauses in the contract. The best protection in China is actually foreseeing these types of problems and writing these into the contract. So thank you again for reaching into this session. I think again these sessions are just making it more and more important that getting things lined up right at the start is your surefire way to have a successful relationship in China. So thank you.